part, and that is the United States Supreme Court and affirmative action. And I will talk about one other court decision. The current debate about affirmative action can really be traced back to a 1978 decision of the U.S. Supreme Court. And that decision is Bakke versus the Regents of the University of California. Mr. Bakke was a white applicant to the medical school of the University of California at Davis, California. He had applied 2 times and been rejected. He then sued, arguing that the affirmative action program of the university was unconstitutional. The program operated this way. There were a total of 100 seats in the first-year class of the medical school. And the affirmative action program in the school operated in such a way that it set aside 16 for minorities. Minorities as I have described earlier. The plaintiff argued that that program violated Title VI of the Civil Rights Act of 1964 that I mentioned was such an important Civil Rights Act that prohibited racial discrimination, not just racial, but on the grounds of gender, religion. That act was violated by this program of the University of California. This decision, extremely important. There are 9 Supreme Court justices. This is the way the vote went. 4 were in favor of the program as being constitutional. 1 thought that it could be constitutional, and 4 were automatically against its constitutionality. This one justice, Justice Powell, was the what we call swing vote. It was his vote, if you will, that was crucial in the decision. Now, while the program itself, the program as run by the University of California at Davis, was in fact struck down. In other words, Justice Powell found that it was in fact the way it was run unconstitutional. So along with these 4 justices who voted against it, that was the majority, 5-4. Right? But with these justices, he did feel that there was a place for a consideration of race in admissions. And in Justice Powell's view, he felt that educational institutions could take diversity of all kinds into consideration when deciding what their first-year class is going to look like. Certainly, there's no question that universities look at regional diversity. We know that there are special admissions for children of alumni. If your parents went to the school, you're in a better position. If, for example, someone in your family or someone you know gave a great deal of money to the university and wrote a note to the university saying, I really want this person to get in, that person could get in, that was fine. If the university wanted, for example, to admit students who would play in its orchestra, they could give those students a higher rating than someone who maybe had higher scores. If the university wanted to have a strong football team, basketball team, water polo team, you name it, they could give those individuals a higher place than people who got higher scores. All of that's fine. But if the university wants to have racial diversity, then for some people that's a problem. And so Justice Powell said he felt that racial diversity, because it would lead to an exchange of diverse viewpoints, just as geographical diversity could do that, he felt that if you could have a program that took race into account. Now, let me start by saying the U.S. Supreme Court has yet to speak thoroughly on this issue since 1978. But it has spoken in related areas. And when I say this issue, I mean the use of race in admissions at the university level. What are the other decisions that the court has in fact decided? The next important decision is the City of Richmond versus Croson, and that dates from 1989. the city of Richmond had a set-aside policy where it provided that a certain percentage of all city contracts would be granted to minority-owned businesses. And when I say minority-owned businesses, that does also include businesses owned by white women. Most jurisdictions had a law like this, so these laws were pretty common throughout the United States. Well, in the Croson decision, the Supreme Court, a majority or plurality, we say, of the Supreme Court held that that is unconstitutional. That you have to prove that the situation that exists with respect to contracting is related to some action by the government. And just let me give you a few of the facts here. In Richmond, let's see, there were 50% of the population in Richmond was black. Yet, only 0.67% of all city contracts went to blacks. So 50% of the population is black, but only less than 1% of all contracts went to blacks. In the history, Richmond, after all, was the heart of the Confederacy. That's why this decision was so stunning when it came out, because everyone knew what the reality of the situation was in Richmond. It was like a return in some ways to the Plessy decision back in 1896, where the court said separate but equal doesn't mean that black people will be in a worsened position. Separate but equal means that black people can't be with white people, but it also means that white people can't be with black people, so they're treated equally. Okay? Here the court had this record of discrimination in the city of Richmond, where these contracts had not been granted. And the city of Richmond, through this conscious allocation of resources, was attempting to address this situation. Then the court decided, 1 year later, the case of Metro Broadcasting, just to make life interesting. Versus FCC, this is 1990. Now, the Croson decision involved a city plan. The Metro Broadcasting case involved a policy, two policies actually, of the Federal Communications Commission. That is the federal agency that is responsible for administering, for regulating the communications industry. Telephones, television, radios. It allocates channels. It allows people to buy stations. Well, this organization, recognizing that minority-owned businesses and businesses owned by white women were very underrepresented in the communications area, and recognizing the importance and the significance of communications and diverse viewpoints, had a program that gave preference to, in certain circumstances, minority and women-owned businesses. Now, in that case, when that program was challenged, a majority of the Supreme Court held that the program of the FCC was constitutional. And how did the court distinguish the Croson case? The court distinguished the Croson case because, looking at the 14th Amendment of the Constitution, there is a provision in the 14th Amendment that states that Congress, having decided that there are violations of the 14th Amendment, can indeed enact statutes and laws in order to address that discrimination. So the court said, because Congress has this what's called plenary power, that comes from the Constitution, has greater authority, greater expertise than cities do. And Congress delegated that authority to the Federal Communications Commission. So after the Metro Broadcasting case, you found people thought, well, federal affirmative action programs are constitutional, state affirmative action programs are not. And that indeed was the case until 5 years later, the Supreme Court decided the Patterson case. Patterson versus Kenya in 1995, which involved contracts, construction contracts, and set-asides for minority and owned businesses as well as businesses owned by white women. In that case, the Supreme Court held that whether you take race into account for positive reasons, like redressing discrimination, or negative reasons, that is to discriminate against a group, it doesn't matter. The same legal standard will apply. And it struck down the program because it felt that the organization, the government, had failed to prove that this program was necessary to combat the continuing effects of past discrimination or the current effects of current discrimination. And so now, the Supreme Court appears to be saying that in order for an affirmative action program to be constitutional, it must be in response to existing discrimination or to what can clearly be shown as continued effects of past discrimination. In other words, an organization, the government cannot say, simply looking at the situation, looking at, for example, the allocation of resources in an area, cannot say that this area does not reflect this country and the population of this country, and therefore we want to have this program. That will not suffice. And so that brings us back to the Bakke decision. But before going to Bakke, I have to mention one other very important decision, not of the Supreme Court. And this decision dates from 1996. This is the Hopwood decision. The plaintiff in that case, Cheryl Hopwood, was a white woman who had applied to the University of Texas Law School. And Ms. Hopwood argued that the affirmative action program that the University of Texas had, which was in favor, in this case, of racial minorities, discriminated against her because she had higher scores than the people who were allowed in under that program. And the University of Texas, as the University of California and Bakke, had a two-track admissions approach. In other words, it just didn't take race into account. It had a separate track for minorities and a separate track for everybody else. Now, what's amazing to me about this is that anyone who had read the Bakke decision would have known that that's not the way you achieve affirmative action in education, at least. But at any rate, the University of Texas continued to do that. Now, I should tell you that the Supreme Court itself, back in the 1940s, had held that the University of Texas operated its law school in violation of the U.S. Constitution. For years, the University of Texas Law School refused to admit blacks. Okay? Refused to admit blacks. So it definitely had a history of overt, state-sponsored, state-ordered discrimination. Even with that history, the Sixth Circuit, and this one's the Fifth Circuit, I'm sorry, and this is not the Supreme Court. The Fifth Circuit held that the University of Texas plan, affirmative action plan, violated the Constitution. But it went beyond that. Because, as I said, the U.S. Supreme Court has yet to address the Bakke rationale. Hasn't done so. But it has decided Croson, and it has decided Patterson. So when the Fifth Circuit was faced with the Hopwood case, it decided of its own that Bakke was no longer good law. Now, no circuit has the right to overrule or reverse a U.S. Supreme Court decision. Only the U.S. Supreme Court can do that. But this circuit was so exercised by this program that it decided that the Supreme Court would no longer follow the Bakke decision. Basically, reversed the plan. The U.S. Supreme Court did not entertain the Bakke decision, the Hopwood decision. It let it stand. It itself did not take the case for review. So the question is still open. Whether an educational institution, a state-run educational institution, may take race into account with a view toward having a diverse student body. That is still the unanswered question in the United States of America on March 8th of the year 2000.